Dictation will start after 5 seconds. Start. It has also been submitted by the Learned Counsel for the appellant that the constructive res judicata is not applicable to the award. The disputes that were raised were not ripe for being referred to arbitration in view of the terms of the contract that the contractor had to raise the dispute before the superintending engineer and thereafter before the chief engineer and had to wait till the end of the stipulated period. It has been further submitted that since the period was not over, the claims raised before the arbitrator could not be raised in the claim petition before the arbitrator, and as such, the second award made by the arbitrator cannot be said to have been buried by res judicata as provided in Section 11 of the Code of Civil Procedure. Neither case for review nor any sufficient cause has been made out for exercising the power of review under Section 114 of the Code of Civil Procedure. The High Court was right in holding that the order of review was unwarranted and directed the arbitrator to dispose of the reference in accordance with law. In view of the provisions of Section 41 of the Arbitration Act, it specifically provides that the provisions of the Code of Civil Procedure shall apply to arbitration proceedings. Contractor has not raised all his claims. The contractor could have raised all his disputes arising out of the contract at that time, but the appellant chose to take only some of the issues arising from the said breach of contract before the arbitrator. He should be deemed to have surrendered those issues and he is debarred from the raising those issues in the subsequent claim petition made before the arbitrator. As per agreement, the rates will not be enhanced if they are agreed once. Department is not bound to pay the claimant a revision of schedule. It has been further submitted by the learned counsel on behalf of the respondents that the appellant was not entitled to an increase in the rates as he claimed increase with the agreement, and the claim that has been made is untenable. It has been lastly submitted on behalf of the respondents that the arbitrator has misconducted himself and the proceedings by not deciding the claim filed by the government while considering the claim filed by the appellant and making an award. The case was remanded to the arbitrator, and the question is that whether it is sustainable or not. The trial court set aside the award and remitted the same to the arbitrator for making a fresh award. On an application for review, the trial court set aside the order and passed a decree in terms of the award. It is not disputed that the arbitrator did not consider the claims at all and kept the same for consideration while making award in respect of the claims filed by the appellant. Undoubtedly, this is not sustainable in law. In the instant case, the contract was terminated by the respondents. Thank you.